Welcome to the Bar Exam Toolbox podcast. Today we are going to do another in our Listen and Learn series. This one's on special privileges in evidence. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we love to hear from you. And with that, let's get started. Today, as part of our Listen and Learn series, we're discussing evidence, specifically some special forms of privileged communication. We'll look at what parties have special privileges when it comes to their communication, who those privileges belong to, and what exceptions exist that may allow otherwise privileged communication to be omitted. The main forms of privilege we're going to look at today are spousal, doctor-patient, and clergy-penitent. There's another important privilege to learn about, attorney-client, but we'll be discussing that in another podcast. Before we discuss these groups, let's discuss what a privilege is. A privilege is a legal rule that protects communications within certain relationships from compelled disclosure in a court proceeding. In other words, within some special relationships, parties cannot be forced to give testimony about communication, including nonverbal communication, within that relationship. In some situations, which we will discuss, parties can never give testimony about privileged communication, even if they want to testify. It's important to note that privilege isn't the same as confidentiality. The rules of confidentiality for certain professionals, such as doctors, therapists, and attorneys, are set by the ethical code of conduct for these professions. Privilege refers specifically to admissible testimony during legal proceedings and falls under the evidence rules. Under the Federal Rules of Evidence, privilege is covered under Article 5. The General Rule of Privileges, FRE 501, is pretty open-ended, as most of the actual rules of privilege are laid out by case law and state statutes. However, FRE 502 goes into attorney-client privilege in more detail, which we will discuss in a later podcast. The first type of privilege we're going to talk about is spousal privilege. Also known as marital privilege, spousal privilege is meant to protect the special relationship between married couples. Under the umbrella term of spousal privilege exists two distinct privileges: the marital communications privilege and the spousal testimonial privilege. The marital communications privilege applies in both civil and criminal cases and protects communications made between spouses during the marriage. The privilege only applies if the communication was intended to be private and made in reliance on the sanctity of the marriage. This privilege belongs to both spouses, meaning that either party can assert the privilege by refusing to testify about communications within the marriage or by preventing the other party from doing so. The marital communications privilege can outlast the marriage, even if the parties divorce or one of the spouses dies. Any communication that occurred while the marriage was intact is still privileged. This is because the central idea of the marital communications privilege is that spouses should be able to speak openly and honestly within the marriage. Things said between married couples can't later be used against one of the parties in a legal case, even if the marriage eventually breaks down. In contrast, the spousal testimonial privilege is only applicable in criminal cases and is held only by one spouse, not both. Under spousal testimonial privilege, the spouse of a criminal defendant cannot be forced to testify against his or her partner. However, the spouse can choose to disclose about events during and even before the marriage, if they do wish to testify. Unlike the marital communications privilege, the spousal testimonial privilege does not outlast the marriage. It is terminated if the spouses divorce. This is because the spousal testimonial privilege is designed to protect the spousal relationship, not necessarily the specific communication between the spouses. The idea here is that we don't want to force spouses to testify against each other, as it could jeopardize their relationship. There are a few exceptions to both forms of spousal privilege. The first is if the communication was ever revealed to a third party. If the information was shared, the parties cannot then claim it is privileged between the spouses. The second is if one spouse is suing the other, for example, in a divorce action. The third is when one spouse is charged with a crime against the other or against their shared children. A classic example would be in the case of domestic violence, where the victim's spouse will be permitted to testify about the communication and behavior of the abusive spouse within the marriage. The next type of privilege to know about is doctor-patient. While there is no one common law rule on doctor-patient privilege, all U.S. jurisdictions have some form of statute protecting this type of communication. Most jurisdictions extend doctor-patient privilege to mental health professionals, such as psychologists and licensed therapists. While states differ in how broad this privilege is, there are some general requirements for communication between a doctor and a patient for it to be considered privileged. First, there must be an actual doctor-patient relationship between the parties at the time of the communication. Second, only information needed for actual medical care is protected. Extra details not related to the patient's treatment aren't protected just because they are said to a doctor. Finally, the communication must have been shared with the expectation of privacy, meaning it can't be made in front of a third party or in a situation where privacy isn't reasonable, such as a crowded hospital waiting room. Each jurisdiction has its own rules and exceptions on when doctor-patient privilege applies, but generally there is an exception for cases where the doctor has an obligation to testify about types of illnesses or injuries, such as sexual abuse, gunshot wounds, or venereal diseases. Doctors will also generally be permitted to use otherwise privileged communication to defend themselves from civil suits, such as against allegations of medical malpractice. Similar to doctor-patient is clergy-penitent privilege, sometimes known as priest-parishioner privilege. This privilege protects communications between a religious leader and an individual seeking spiritual counseling. This privilege is not limited to Christian religions, as the name might suggest, but can extend to a variety of spiritual leaders, such as rabbis, imams, etc. In order for the privilege to apply, the communication must have been made directly to a clergy member who was acting in a spiritual capacity, and it must have been intended to be confidential. Some recent cases have questioned if statements made during group support meetings, such as Alcoholics Anonymous, fall under the privilege, as those groups often center around a spiritual purpose. However, courts have largely limited the privilege to individual members of the clergy and have not extended the privilege to group spiritual practices. In some states, specific exceptions apply that compel clergymen to testify about specific crimes that are disclosed, such as the sexual abuse of children. Now that you understand these forms of special privileges, let's look at some hypos to see how privilege may come up on the bar exam. Let's first look at a question adapted from the February 2009 California bar exam. Defendant Dustin has been charged with robbery, and his ex-wife Wendy has been called to testify. Dustin and Wendy divorced prior to the trial. Wendy willingly testified that she spoke to Dustin the day of the murder, and he told her that he had, quote, pulled off a big job, end quote. The court now needs to decide if Wendy's testimony would be permitted under the spousal privilege rules. So let's first look at the spousal testimonial privilege. First, Wendy is the holder of the privilege, since she is the non-defendant spouse in a criminal case. She can decide if she wants to testify. Second, since Wendy and Dustin are no longer married, there is no risk to their relationship, which is what this privilege is meant to protect. Therefore, the spousal testimonial privilege doesn't apply here. Now, what about the marital communication privilege? Now, that probably will apply in this case. Even though Wendy and Dustin are now divorced, any communication they had while they were still married falls under the privilege. Since this privilege belongs to both parties, even if Wendy wants to testify against Dustin, he can prevent her from doing so by asserting the marital communications privilege. Now let's look at some slightly more complicated examples from the July 2012 California bar exam. Defendant Dean is charged with the murder of his business rival Vicky. He is alleged to have hidden in some muddy bushes before ambushing Vicky. At his trial, the prosecutor calls Dean's wife Whitney. While Whitney had originally agreed to testify against Dean, she changed her mind on the stand. When the prosecutor asked Whitney if she saw mud on Dean's shoes on the night of the murder, Whitney refused to answer. The prosecutor threatened to charge Whitney with contempt, so she reluctantly answered that she did see mud on his shoes. Should the court have allowed Whitney's testimony? Does it matter that Whitney isn't giving information about specific communication from Dean? The answer to both these questions is no. The information on the mud on Dean's boots should have been protected by a spousal testimonial privilege. Dean and Whitney were still married at the time of the trial, and Whitney is the holder of the privilege. To protect their marital relationship, the spousal testimonial privilege allows Whitney to refuse to testify against her spouse, even just about the mud on her husband's shoes. Therefore, the court erred in allowing the prosecution to threaten Whitney with contempt and forcing her to testify. Now let's look at a trickier question. In this same case, the prosecution called Dean and Whitney's neighbor, Ella. Ella testified that on the night of the murder, she was standing at her open window and overheard Dean and Whitney talking. She overheard Dean say to Whitney, "I just killed the gal who stole my biggest account." Dean and Whitney didn't know Ella was listening to their conversation. Let's say that we have already determined that Ella's testimony is not hearsay. Should the court have permitted Ella's testimony about a statement she heard between Dean and Whitney? The answer is probably no. Dean can assert the marital communications privilege, as he made the statement to his wife with the expectation that the statement was private. The marital communications privilege is meant to encourage open communication between spouses during their marriage, and to allow Ella to report that conversation would go against the purpose of the privilege. So even though Ella is not Dean's wife, he can still assert spousal privilege to prevent Ella from testifying on his conversations with Whitney. And with that, we're out of time. Hopefully you found these hypos to be good examples of how to work through a privilege issue on an exam. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or alison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.